What is it? So Almat is some post there.
Almad is the court reader, my lord. It's below the reader. The Almad is, there is a reader and then there is an Almad. The custodian of the record, yes, so to say.
I thought there is somebody called Ahmad. So he directed Ahmad.
No. The restorer blood who keeps the files. It's a restorer who keeps the files. Blood. It's called Almad.
Record keeper.
Almad, yes.
Ahmad.
He's given a bigger degree blood than a clerk.
This is what a Punjabi word.
Correct.
Urdu.
He's a powerful man in the court.
In fact, most powerful person.
In commas. So
Somebody like a Sharistar, we call it, is it? No.
No, blood.
There is court reader.
He's court reader, blood. In fact, he's the custodian of entire files of the
Yes,
court.
yes.
Blood, in fact, he is having the key of the Almira where the files are kept. So he's the most powerful person in the court.
he issues notices, summons, everything. Almad is doing.
No,
All right, yes.
So, my lord, just see. So, this order is completely illegal in my respectful submission. I am not a party at that point of time. I did not challenge it.
No,
But
here in this case, this one trial in the main case has not been concluded.
Not on this date. No.
In this case,
Yes,
particular case.
yes. Not on this date. No, in this case, trial is complete. Today it is complete. On the day when the order is
In this, the judgment you read, some application is filed during the trial.
correct. This very case. I'm reading this very judgment.
What he does, he separates his application. He decides to-
Where is the order passed on this application?
I'm coming to that. I'll just give me 2 more minutes. I'll read it.
That is passed on the same day.
No, that is passed later. That ultimately judgment is of 31st October and order will also be passed on
On
31st.
the same day.
Yes, same day. After, I'll read the judgment and the order.
Only one submission. Blood. In fact, the Honorable High Court had ordered that the trial be expedited. So
Correct.
the trial only I'm just giving the reason for bifurcation.
That reason is already reflected.
Yes, that is there in the order.
He has already read that.
Yes,
Yes, right.
that is the reason.
So,
The reply is filed by whom? To this application?
the other accused, he issues notice in this application to all the other accused.
Not to you.
No. If your lordship will have page 536.
But as proposed accused, he is not summoned, he cannot appear, he cannot.
We are aware about that. There is a judgment by Justice Bobde.
Yes.
Yes. Which says that he should be given notice.
No,
He should
proposed
not be given
accused
notice.
cannot.
There is a judgment by Justice Bobde which says that a notice is not necessary.
Not because he is a proposed accused, he cannot be like
I
156.3.
will cite that.
Like 156.3, he can't.
I will cite that where it says notice should be given. But anyway, I'm not on that. That is neither here nor there. We are far beyond that stage today. So 536 he gives he gives notice to the other accused. If your lordship will see the earlier order of 21st September, he says prosecution has filed an application. This is the first day when the application comes up. The order is at page 536. One page before. 21st September, the application is filed. So it is the first day it comes up. Prosecution has filed an application under section 319 CRPC. The other accused requested to give opportunity to file reply. Accordingly, the case is fixed for 28th September for filing reply. So on the second date itself, he then passes this order. Now, the second part of the order is equally interesting, Lord. I have read. So the Almad is directed to separate the application under 319 and register this as a criminal miscellaneous is unknown to law. It is doing violence to 319. He cannot separate it. The application is integral to that trial.
Let us read further.
Yes.
For separating.
For separating present trial and application under 319 CRPC, I rely on 1999 1 RCR criminal 283. There is no judgment on this page. I have done my research. If I am wrong, my lord, the Learned Advocate General's office can find out. This citation is wrong. There is no judgment on 1999 1 RCR criminal 283. There is no such judgment. But in any case, I think probably either the page is wrong or the year is wrong. We have tried to do 10 pages up, 10 pages down. Also, nothing could be found. So probably the year may be wrong, but that was too much of, I do not know which judgment he is relying. Now, where our own Honorable Punjab and Haryana High Court has held, one of the accused went abroad, not available, trial lingering, trial court directed to take appropriate action for splitting case. In any case, what he is relying on is totally different. That is not a 319 case where an accused is abroad. There, my lord, 3172 gives power to him to separate trial, and therefore therefore that power can only be exercised in case of a person facing inquiry or trial. So therefore, this whole concept of separating trial in 319 is unknown to law. It cannot be done. I'll show 3172 also. So for separating present trial and application under 319, I rely upon 1999 1 RCR Criminal 283, where our own High Court held one of the accused went abroad, not available, trial lingering on. High Court directed to take action for splitting the case. Further, as already discussed above, this case pertains to 2015. 10 accused are facing trial. 2 are on bail, remaining are in custody. Let APP request for adjournment for prosecution evidence. My mind, prosecution has sufficient opportunity. So I need not read the rest of it. The next steno of this court is directed to print 2 copies of this order. One is to be placed on this file, and this file is fixed for recording statement of accused under 313. Other copy is to be placed on criminal miscellaneous file, and criminal miscellaneous file is fixed for consideration of application under 319, which is fixed for 4th October, etc. So he separates it, which according to me, he cannot do. It's completely illegal, this order. Then what he does, he decides the main case. Now kindly see the judgment in the main case. I just want to show the index and then one para of the judgment, because yesterday I said this application is not mentioned. I stand corrected. It is mentioned. So that is, judgment is in volume 3, R3, this very. kindly have this volume, just have the very first page of the judgment. The judgment is rendered in session case number 289 of 2015. The application under 319 was filed in this session's case. Now, just kindly take page 9 of this judgment. I just want to show your lordships. It records that the para in the lower half of the page, after completing necessary formalities, challan was presented against 10 accused by mentioning that investigation is pending against the remaining person. And after completion of investigation, challan against them will also be presented. So there was only one more accused original. So there is his challan is much later. It comes in 2019. So therefore, there is no trial or inquiry pending against him. Then kindly have page 84, where this application is mentioned. Page 84. What he says in this judgment at page 84. Para and bottom of the page. Learned APP further argued that during investigation it is transpired that kingpin behind the whole sequence was Sukhpal Singh Kheda, who through his personal security officers Joga Singh and Manish and Charanjit Kaur were behind the curtain, argued that summoning these accused an application under 319 has been filed, which is pending for today. Then he records in brackets, application for summoning accused is also filed, which is separately registered as criminal miscellaneous because High Court has directed to dispose of this case. And which application this court is going to decide today itself by separate order. Now, this is absolutely incorrect. He has no inherent power of like a 482 or a 151 CPC. He is bound by the.
So this makes it clear that he has decided it after the.
Correct.
The judgment is pronounced.
Correct. That the second order also says that today I have already pronounced my judgment. That order will also say that. So therefore, now kindly have that order by which the application is decided, because that application is not being decided in this session trial at all. It is a separately numbered criminal miscellaneous. How is it even maintainable? Is the question, is the first submission, my lord. Just kindly see that order, my lord. That is at page 121 in the main paper book itself. Page 121 of the SLP paper, the first paper. Kindly see the top. Criminal miscellaneous number 339 of 2017, filing ID CNR, the trial number is missing. It was session case 289 of 15. So he's not deciding it in that session case at all. Because according to him, he's made it a separate standalone application today. This order is completely against law on this ground alone. Then he records this order of mine will dispose of an application, etc. On facts, I'm not going into it. Then he says at page 128, sorry, 130. As things stand out, this FIR was registered and challan against 10 accused was presented by mentioning that after investigation, the challan against the remaining accused will also be filed. Till date, no challan is presented against the accused whose names are mentioned. By my separate judgment, all accused against whom challan was presented, except one, are convicted today. Then proceeding was separated because High Court said decide quickly, etc. So therefore, he also records that I have already decided that. So, my lord. So therefore, my lord, the submission is that this order is completely against law. It is completely illegal because he himself separates it from the trial. Now, where is his power to separate? That is 317. Kindly have 317. When can he separate? 3172. And which trial he can separate? It is only against an accused against whom an inquiry or trial is pending. 317, the title is Provision for Inquiry and Trial being held. I'm sorry. Not this, 317.
Yes.
All right. 317 says provision for inquiry and trial being held in the absence of the accused in certain cases. One is not relevant, but for the sake of completedness, I will read it. At any stage of an inquiry or trial under this code, if the judge or magistrate is satisfied for reasons to be recorded that the personal attendance of the accused before the court is not necessary in the interest of justice, or that the accused persistently disturbs the proceedings in court, the judge or magistrate may, if the accused is represented by a pleader, dispense with his attendance and proceed with such inquiry or trial in his absence, and may at any subsequent stage of the proceeding direct the personal presence of such accused. Now, next is relevant. If the accused in any case is not represented by a pleader, or if the judge or magistrate considers his personal attendance necessary, he may, if he thinks fit, and for reasons to be recorded by him, either adjourn such inquiry or trial, or order that the case of such accused be taken up or tried separate. So under 2 says, if he thinks for reasons to be recorded, he has 2 options. Either he can adjourn the entire inquiry or trial, or he can, in the case of such accused, order that the trial be separated and taken up separate. But it is only against an accused who is facing an inquiry or trial. It is not an application under 319, because 319 says in the course of any inquiry or trial. Now, if you are application file, you are segregating it and registering it as a criminal miscellaneous, it's violence to 319, in my respectful submission, apart from anything else. So therefore, my lord, this is the second submission which I am making, why this order should be set aside. Then, my lord, I must also show your lordships one other order which according to me has no legal significance at all. But that is an order dated 31st October. He passes judgment of conviction, etc. He passes this order. Then he passes one more Zimni order, my lord. Kindly see that also. Or the third order which he passes on 31st of October. That is again the second volume R2 at page 547.
Page
547, that thick volume. Yes. (547) kindly have arguments heard. Now again, if your lordship will see this, I'll read the first right from the one. In fact, in seriatim, this would be the first order. Then second is the judgment, and third is on that application under 319. He says no DW is present, neither opted to be examined. Arguments heard. By my separate detailed judgment of even date. No, this is the second one. Judgment is pronounced now. Arguments heard. By my separate detailed judgment of even date, accused, the names are given, are convicted under NDPS Act, whereas accused Kala Singh acquitted. As accused Anil, alias Neelu, has been declared as proclaimed offender, so file be completed and consigned to the record room, be put up as and when Anil Kumar Neelu surrenders before the court or proceeds by the police. Contraband material involved stands confiscated, same be disposed of as per rules. Now he consigns the file to the record and says, whenever Anil Kumar's case comes, please put this up again. So according to me, this is not an order under 3172. Cannot be, because Anil Kumar is not even facing.
What are the arguments heard?
Yes.
So this is prior to sentence or what?